Jerome Johnson here.
Mr. Ron Brown, this is your case?
Ron Brown appearing on behalf of Mr. Johnson. I think this was nollie crossed, Your Honor.
The courtroom opens with a deceptively simple moment, but don't let that calm tone fool you. A case dismissed without prejudice might sound like a clean exit, but legally, it's anything but final. This means the prosecution still holds the power to bring the charges back at any time, keeping the defendant in a state of uncertainty. And that uncertainty, that's where the real tension begins. You can already see how quickly things move in this courtroom. Decisions are sharp, procedural, and final in tone, even when they're not final in substance. What stands out here is how casually a major legal outcome is delivered. No dramatic buildup, no hesitation, just a ruling that quietly reshapes someone's legal future. That's the nature of real courtrooms, high stakes, delivered in seconds. And if this is how the session starts, the question is, how much more intense is it about to get?
Yeah, I think the court should be in possession of an order of nolle prosequi.
I am.
Yesterday.
All right, this case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
I just
Thank
got
you, Mr. Brown.
I just got a question. How is this? Is that would be immediately dismissed?
Yes, sir.
Okay.
My name's on the paperwork, so if you're talking immediate, it just happened.
Okay. Thank you.
Thank you.
Good one.
Court calls the cases of the People versus Tierra Quinton, 2 cases.
Good morning, Your Honor. Grace Burton appearing on behalf of the people.
First Assistant Public Defender Kalina Anderson with on behalf of Ms. Quinton. Your Honor, we're appointed on the 795. I did submit a request for public defender for the 5677 file.
Yes, I do see that. So I'll just sign that. All right. That's an arraignment in that file. Quinton?
Yes.
Okay, state your name, please.
Tiara Quinton.
All right, Miss Quinton, you are before the court. Before I get to that, I do have to apprise you that you're before the court on the charge of, they give me the information? Probably not. Of course not. Oh, no, they tuck it in the back. No, they didn't. Oh, you're here before the court on the charge of possession of methamphetamine and or ecstasy. You understand that, ma'am?
Yes.
That's a 10-year felony or a felony punishable by 10 years or $15,000 fine plus court costs. You understand that?
Yes.
All right. You wish to be represented by the public defender in that matter?
Yes.
This is a public defender case.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with on behalf of Ms. Quinton. Your Honor, as to the complaint, we'd stand mute and ask for a probable cause conference date.
Now the tone shifts, and fast. What we're seeing here is the formal entry into a felony level case, and not just any charge, possession of methamphetamine or ecstasy, carrying potential prison time and heavy financial penalties. The judge lays it out clearly, up to 10 years or a $15,000 fine. That's not minor, that's life-altering. And notice how the system moves. Representation is assigned, pleas are entered, and everything is processed with efficiency. But beneath that efficiency is pressure. The defendant has to respond, understand, and make decisions in real time, often with limited preparation. This is where legal clarity becomes critical. The public defender steps in, enters a not guilty plea, and requests a probable cause conference, essentially buying time to evaluate the evidence. But here's the real question. Does the defendant fully grasp what's at stake at this exact moment? Because once this process starts, there's no slowing it down.
All right. Defendant having waived for further formal reading and standing mute, court will enter a not guilty plea. And you want this set with the other matter, is that correct?
Yes, Your Honor. I was going to ask for an adjournment of the other PCC so that we can have both cases on one docket.
All right. So the PCC, let's do this. Let's adjourn the PCC to the 28th, 2023, 9 a.m. Bond will continue on that matter. back to the arraignment. Hope I'm not messing you up, Ann. I'm sorry. I'll set bond in that case at $10,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or weapons. There's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I'm also going to order, can I see that file? What supervision was she under? I'll order community correction standard supervision for testing. You got that?
Yeah.
Okay. And I'll set the probable cause conference in this matter for September 28th, 2023, 9 a.m. or as your Zoom invite indicates. All right.
This is where structure takes over the chaos. The judge is now locking in procedural control, setting bond, imposing conditions, and scheduling the next legal checkpoint. A $10,000 personal recognizance bond might sound like freedom, but it comes with strict conditions: no drugs, no alcohol, no weapons, and behavioral compliance. One violation, and everything collapses. What's critical here is how the court balances risk and trust. The defendant is being allowed to remain out of custody but under tight surveillance. And then comes supervision, testing included. That signals concern from the court about potential ongoing behavior. This isn't just about punishment, it's about control and monitoring. The legal system is now fully engaged. And from this point forward, every action the defendant takes can either strengthen their position or completely destroy it.
I think we got all that.
Thank you, Your Honor.
Thank you, Judge.
folks.
Last.
Get to that jail.
Yep.
Court does call the case of the people versus Jason Garrett.
Nicole Hughes on behalf of the people.
Good afternoon, Your Honor. Excuse me. Good morning, Your Honor. Marcia Creature on behalf of Jason Garrett, standing in for Mr. Robert Killawall.
Mr. Garrett, can you state your name, please?
I like to.
All right. Okay, what are we doing?
Your Honor, Mr. Killawall is requesting an adjournment of this matter, given the fact that he was just appointed and he visited Mr. Garrett, I believe, last night in the Washtenaw County Jail, but he's got some items to talk over with Mr. Garrett. So I'll be asking for a 3-week or 2-week adjournment.
Objection.
What's your objection, sir?
I won't be leaving this chair anytime soon, so therefore I think we should just do a breakout room with my attorney and continue this matter.
Okay. Here's what I'm going to do. I'm going to give your attorney, Mr. Killawall, an opportunity to come down and talk with you instead of doing a breakout room with Ms. Creature. And so the court is going to find, under the circumstances, good cause to adjourn this probable cause to the 21st, 2023 at 9 a.m. I understand that may be over defendant himself's objections, but the court is going to do that. His bond will continue. Thank you.
Now this is where courtroom tension becomes visible. The defendant objects, but the court moves forward anyway. That's a critical moment. It highlights a fundamental truth about the legal system. The judge has the final authority, even when the defendant disagrees. The request for adjournment is granted, not because it's convenient, but because the court finds good cause. That phrase carries weight. It means the judge believes there's a legitimate legal reason to delay proceedings. But from the defendant's perspective, this can feel like being stuck in limbo. No resolution, no progress, just more waiting. And waiting in a legal case can be just as stressful as the outcome itself. The judge keeps the bond in place, maintaining stability, but the delay introduces uncertainty. And uncertainty, in a criminal case, can be dangerous.
Wait.
Thank you, Your Honor.
It's whatever you had before.
Okay, that's the end of the block. We've called some. I'm going to let my staff get set up with the 11 o'clock case. Angela Weems.
Good afternoon, Your Honor. Ashley Lonnie for the people.
Good afternoon, Robert J. Kilwall, presently Angelo's attorney.
All right. I have from you, let's deal with this first. I have your motion to withdraw in the matter. Go ahead, sir.
No, that's correct, Your Honor. Mr. Weems doesn't feel like I'm doing the proper job for him. The communication's pretty much stopped. I wish him well on his future case, but he does not want me on the case.
Mr. Weems, is that correct, sir?
Yes, Your Honor.
All right. All right, I will grant the motion to withdraw. Sign that one, and then there is having granted that, actually I'm signing 2 orders, but that would mean that the assigned council manager has selected Erica Julian to represent the defendant.
Good afternoon, Your Honor. Erica Julian now appearing on behalf of Mr. Weems.
So I have defendant's motion for bond at this time, and that was filed, I believe, by Mr. Kilowald. Would you be prepared to go forth on that bond motion, or you want me to put this out so that you have time to prepare and talk to Mr. Weems?
I would prefer the latter, Your Honor. I did receive a preliminary police report, so I could at least briefly meet with Mr. Weems yesterday. And we were able to have that meeting, and we did have a conducive meeting. We had a good report to begin with, and but there's a great deal of discovery that I have yet to receive. And I think that would be important to have before going forward with the bond motion.
This is where the complexity of the case explodes. A great deal of discovery. That's not just a casual statement. That's a warning sign. We're talking about 85 videos, reports, and potentially critical evidence that could shape the entire case. And when a defense attorney asks for time, it's not hesitation, it's strategy. Rushing into a hearing without reviewing evidence is a guaranteed mistake. But here's the tension. The prosecution wants movement, while the defense needs time. That's the constant push and pull in criminal law. One side wants resolution, the other wants preparation. And the judge has to balance both. The mention of a homicide charge raises the stakes even further. This is no longer routine. This is serious, high-level criminal litigation. And every delay, every decision carries massive consequences.
So I'd be asking to put that off, as well as an adjournment for about a month, about 4 weeks out, just because I understand that there are about 85 videos that I would need to download and review, as well as receive a medical examiner's report, additional discovery from Mr. Kilowald. There's just a great deal going on.
Any response on any of that from the people?
Your Honor, it does seem to make sense that Ms. Julian would need some time to get caught up in the case. I will let Ms. Julian and the court know that the co-defendant, Ms. Williamson, is currently scheduled for preliminary examination on October the 10th before Judge Burke. It would, of course, be the desire of the people to hopefully do one preliminary examination between these 2 defendants. So I don't have an objection to the request for adjournment. My request would be if we could maybe consider a shorter adjournment for the probable cause conference, perhaps to the 21st if the court's willing, and then schedule the preliminary examination for October the 10th. And I will do everything I can to make sure Ms. Julian has all the information.
Do you think that would work for you, Ms. Julian? And maybe that's the wise way to go. That way you could meet with Mr. Weems, discuss what you can discuss, and then we would still have a little bit of room in there if we needed to before the 10th comes around.
I do understand, Your Honor. I know that the co-defendant is charged with being an accessory, and Mr. Williams is charged with the homicide itself, and that there's been investigation done, as well as additional investigation that may need to occur. So it's difficult for me without having everything now to guess whether or not it would be ample time or adequate time to be ready to go on a homicide prelim on October 10th.
Well, here's the other option. And what I'm going to do is this. I think I'm going to put it out to the 28th. And then what we can do at that point is figure out where you are.
The judge steps in again, this time to control the timeline. When cases involve multiple defendants and overlapping evidence, coordination becomes everything. The court is now thinking ahead, trying to align schedules, evidence review, and procedural fairness. This isn't just about one defendant anymore. It's about managing an entire legal ecosystem. The judge even considers coordinating with another judge to keep proceedings aligned. That level of oversight shows how complex this situation has become. And then comes the key move, pushing the case forward while still allowing flexibility. It's a calculated balance between efficiency and fairness. But here's the real issue. Can the defense realistically prepare for a homicide-related preliminary exam within this time frame? That uncertainty is still hanging in the air.
And maybe even loop Judge Burke into the conversation so that maybe he might put the other one off a little bit to allow everybody to be together if that were what was going to happen.
That works, Your Honor. Thank you.
And Your Honor, the only difficulty is unfortunately I'm not available on the 28th. So if Ms. Julian, if you do want that date, there will be another prosecutor covering. Otherwise, we could look at the 5th, knowing that the idea may be to go ahead and move to an exam 5 days after that. I just want to do the best to consider this. The court knows that this matter has been pending for some time. The people have never objected to an adjournment from the defense. But unfortunately, with having the two folks going, we do sort of need to move this case along as well.
All right. So let's do this. I'll adjourn the probable cause to the 5th of October. That's actually that 30-day range you were looking for it anyway, Ms. Julian.
Yes, Your Honor.
At 9. Well, yeah, the problem is, you know, at this point, what I'm going to do is I'm going to deny without prejudice the motion for bond, so that if you seek to raise it again, you may. That way I can put it in the 9 o'clock block and do it that way, okay?
Yes, Your Honor.
And then we can look at that, and then we can always try to work with Judge Burke to just in terms of scheduling and time and the like. Okay?
Yes, Your Honor. Thank you very much.
Right. Thank you.
I have the lab report regarding the death, and I have a pretty big thumb drive. I'll drop off at your office tomorrow.
That sounds great. Thank you, Mr. Killewald.
Thanks.
Okay, you got all that, Mr. Weems?
Yes, sir.
Yeah. All right. So this bond will continue as denied at this point. Thank you, folks.
Thank you.
Thank you, Your Honor.
Now that's it for us, correct? 14A stands.
Everything now comes together in a controlled but decisive conclusion. The judge denies the bond motion without prejudice. That's critical. It means the defense can bring it back later, but for now, the request is off the table. This keeps the case moving while preserving legal flexibility. The court sets structure, timelines, and expectations moving forward. Throughout this entire session, Judge Simpson maintains control, balancing legal precision with procedural efficiency. Multiple cases, multiple defendants, and varying levels of severity, all handled within a single courtroom flow. The key takeaway? The legal system isn't about dramatic speeches. It's about calculated decisions made under pressure with long-term consequences. Every ruling here shapes what happens next. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.